I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are going to be jumping into number 53 in our compilation video series. Today, we will also be in 3 different judges' courtrooms, all out of the state of Michigan. Before I give you the rundown of those judges, just remember there will be no commentary added to this video, and also there will be chapters added for your convenience. These are some classic moments that we've shared here in the past on the channel. And man, the reaction that I've been getting from these videos, I'm super surprised that many of you haven't seen a lot of these proceedings, but I'm glad that I decided to start this compilation video series some time ago. With that being said, the 3 different judges' courtrooms that we will be in out of the state of Michigan. First, we will be in the courtroom of Judge Brian Oakley. Second, we will be in the courtroom of Judge Anna Marie Anzalone. And last but not least, we will be in the courtroom of Judge Simpson. With that being said, guys, always thank you for all that you do here on the channel. Don't forget to like, share, subscribe, comment. It is much appreciated. And without further ado, guys, let's go ahead and jump into number 53.
Did you want to handle that case right now, Judge Najee Goodman? Mr. Bowditch has spoke to him.
Mr. Bowditch, are you ready on Goodman?
Well, Your Honor, I spoke with Mr. Goodman. Mr. Goodman asked me to tell you that the prosecutor in this case has no power of attorney over him. He's an Israelite. There's no grounds under the barcode this matter should be dismissed. I believe he may want to represent himself. You may ask for some clarification if you talk to Mr. Goodman, but that's what he told me to tell you.
Thank you. Mr. Goodman, are you requesting that you represent yourself on this matter? You're muted, Mr. Goodman.
What I'm saying is nobody has power of attorney law over me through the barcode. I'm the beneficiary. My name is not those capital letters, so I'm an Israelite from the 12 tribes. So what I'm saying is I'm representing myself. That's all that needs to be said, because that's what the law is. I got common law jurisdiction. It's a non-violent crime. So I push for it to be dismissed under the barcode.
Well, it's not going to be dismissed today. So simple question. Are you representing yourself from this point forward? Yes or no?
Yes, I'm counseling myself.
All right, Mr. Bowditch, you're out. Thank you.
Thank you, Your Honor.
I said, are you planning on filing a motion, or would you like to set this case for trial?
I'm planning on filing a motion to dismissal because there's no grounds or no standing over my case, because nobody has power of attorney law to hear me, to even take this process even further. You got to prove that first. You got to prove that you got power of attorney law over me to hear this matter. Okay, I'm an Israelite.
You're saying, but you don't know what you're talking about.
I do know what I'm talking about. You don't have power of attorney law. The prosecutor don't have power of attorney law. You don't have power of attorney law. It's under the barcode.
Mr. Goodman, please do not interrupt me. I'm trying to be polite.
Okay, it's under the barcode, though. This is what you signed up to do. You're a public servant. So
right. Unless you are a price on a can of beans, we don't need a barcode.
Yes, I am. I'm a human being. I'm not a deity. I'm a human being. I'm a living man. I'm a living being. I'm not no cargo. I'm not none of that. It's under the barcode. Okay. This is the real law. Yeah, no standing or no ground.
Mr. Goodman, I'm going to give you a date for your motion.
I'm only here to threaten cohesion.
Pardon me?
I want all my rights intact to me at all times. Do you agree?
I can't understand what you're saying. I think you're too close to your mic.
I want all my rights intact to me at all times. Do you agree?
I can't understand you, so no, I don't agree. I hear you're something
okay,
all the time.
I want all my rights intact to me at all times. I want all my rights intact to me all times.
All right, I can't understand you. Right,
okay.
Are you still living on border? Are you still living on border? Mr. Goodman, are you still living on border?
Ashley, keep yourself muted, please. Your child keeps crying. Thank you.
No, I live somewhere else. I moved.
All right. Can you give me that address, please?
I stay at hotel rooms from time to time because I don't have no house right now. So I've been staying in hotel rooms.
Geographically, where are you at today?
Detroit, Michigan.
All right. So my next pretrial date is when, Heather?
It is March 8th.
All right. So Mr. Goodman, I'm going to give you a date on March 8th to file a motion. You file a motion, we'll hear it on March 8th. That's going to be in person.
Motion for dismissal?
Whatever you want to file a motion. You said you wanted to file a motion. So I'm giving you a hearing date for your motion.
What time?
We'll schedule that at 10 a.m. and this is going to be live. No Zoom.
All right.
I'm having trouble
All right. I want all my rights and text me all the time. I'm only here to threaten confusion. I just want all my rights and text me all the times. And everybody just got to prove that they got power of attorney.
You got to slow down because you're talking so fast. I can't understand you. I keep hearing all time, but that's all I'm getting.
Okay. What I'm saying is for the dismissal, I'm about to put it in today. You got to prove that you got power of attorney law over me. I'm going to have to sue the courthouse for 100-fold.
Mr. Goodman, I don't have to prove a damn thing to you, sir. If you're here on the
you got to prove that you got power of attorney law over me. You don't have power. I don't care what you're talking about.
Over you, Mr. Goodman.
Yes, you do. You need power of attorney law to talk to me. You ain't got no ground. You ain't no standing. You ain't got no ground on understanding. I got the affidavit of truth right here. I got authenticate birth certificate. I got a letter of intent over here right now. I broke all my contracts with the government. I'm not those capital letters. I'm with the 12 tribes of Israel. My name is Israel. I'm an Israelite. I'm with the 12 tribes of Israel. You don't got no power of attorney law over me. I'm pushing for dismissal. I'm suing your courthouse for 100-fold.
422.
Try it again, counsel. I'm sorry.
Good morning, Your Honor. Patricia Manning for the people, P84088.
All right. And Mr. Goodman, can you hear us okay?
Yes, sir.
All right. And Ms. Murphy, what are we doing on these files?
Judge, it's my understanding that Mr. Goodman has an appointment at the Forensic Center on January 31st. As Your Honor knows, he has pending cases in Frank Murphy. He went before Judge Michael Callahan yesterday. He was, his bond was reinstated with a tether. I believe Your Honor has put a 250, 10% bond on Mr. Goodman. You know, Your Honor, that I'm going to ask you to reduce that bond to something affordable.
All right, so I've got two files. One file's got that 250, 10% with a GPS tether. That would be the February 5, 2022 incident date. And then the other file, which is the misdemeanor file from May 10, 2019, he's just on a personal on that one with a GPS tether.
Right, and you know, Your Honor, that I don't represent him on the DV.
Right. But he finally does have a date for a forensic exam?
Yes, Judge.
Okay. All right. So you just want to adjourn the PCC?
Yes, Judge. And ask for a reduction in bond.
Thank you. And Mr. Goodman, have you talked to an attorney on the domestic violence case, or are you representing yourself on that one?
I have nobody to represent me. I think it was Langford or something was supposed to be my attorney. I'm not sure how it went south.
Okay. All right, counsel, go ahead and make your bond argument. But before you do, just so we're all on the same page, my notes say it's $25,000, 10%, no contact with complaining victim, and GPS tether. Is that your understanding?
So, Judge, I thought it was 250,000, 10%, 25,000.
I don't know what I just said, but my file says 250. Well, yeah, 250,000, 10%. Correct.
So, Judge, I mean, obviously that's unaffordable. Mr. Goodman is not a man of means. He and his significant other just acquired new housing, Your Honor. They have a baby. Mr. Goodman needs to be there to assist with childcare responsibilities because both of them were working before Mr. Goodman was taken into custody. I know we've had some issues, Your Honor, with appearing in court. Mr. Goodman has had transportation issues with respect to getting to the forensic center, and that was his issue, Judge. The tether violation was simply a malfunction of equipment. So I would ask Your Honor to, and since they do not have means, Your Honor, I would ask Your Honor to reduce I'm asking Your Honor for a personal with the tether.
Response. And counsel, you don't have to jump up to talk to me. I know it's instinctive, but it's okay if you don't.
Thank you, Your Honor. It is instinctive. Your Honor, in this case, he is before us for a misdemeanor DV. I understand he does have some pending felonies. I understand he's on a GPS tether for the felonies. I believe at this time, the most important thing is that he remain on, or that if he is released, he has remained on a, or he remains on a GPS tether. So in this case, I would not object to a personal bond.
All right. Ms. Murphy, unfortunately, this is one of those situations where I don't care what the parties think, because I've got a long history. This building's got a long history with Mr. Goodman not showing up in court. So I set the bond for that reason. I'm keeping the bond as it is for that reason.
What's your name?
I'm here representing Brian Musgrove.
You're Brian Musgrove?
I'm here representing.
I have no idea what that means. So why don't you come up to the podium?
I had tried to.
Nope, yeah, stand in front of the thing. So what is your name?
Brian Joseph Musgrove.
Okay, are you an attorney? What's your P number?
I'm not an attorney.
So then you can't represent Brian Musgrove. So you are a defendant, correct?
I'm an executor on that estate.
Okay, so none of that is valid or legal. So you have an attorney?
He's not doing nothing for me.
Okay, that wasn't my question. Do you have an attorney? Yes or no?
I have, yeah, he was supposed to be representing me, but.
So you have Michael Dagger Margosian. Okay, so he's your attorney. Okay, so go have a seat. When Mr. Dagger Margosian gets here, I'll call your case, okay? All right, so Mr. Musgrove, you want to come up to the podium, please? This is in the matter of the people of the state of Michigan versus Brian Joseph Musgrove, file number 23-21461FH. I have Isaac Sneed appearing on behalf of the people, and I have Michael Dagger Margosian appearing on behalf of Mr. Musgrove. Mr. Dagger Margosian might, oh, there he is. So Mr. Dagger Margosian, this is a date and time set for pre-trial in this matter. Mr. Musgrove said that he was appearing on his own behalf. I did verify he is not an attorney, and you are still the attorney of record. So Mr. Dagger Margosian, how do you wish to proceed?
Well, Your Honor, I am aware that Mr. Musgrove wants to present information to the court. I'm happy to be standby counsel if he wants to represent himself. Obviously, this court would have to go through the colloquy of that, but obviously it's Mr. Musgrove's legal right to at least ask the court to do that. So I'm here to observe at this point.
All right. So Mr. Musgrove, when you were at the bench or up at the podium before, you said that you were appearing on behalf of yourself. So Mr. Musgrove, are you asking to no longer have counsel represent you?
Well, what I'm understanding is that the courts is a private for-profit.
So Mr. Musgrove, I know where you're going with this, and none of that is valid. None of that is law.
I'm not the all caps name. Of course.
None of that is valid. None of that is law. You are standing in my courtroom. I have jurisdiction over you. So
I tried to file paperwork with the clerk's office ahead of time so that you would have time to review it, and they denied me.
I know what you're talking about. None of that is valid under the law of the state of Michigan or the Constitution of the United States of America.
What do you mean it is?
No.
The Supreme Court says it is.
What does it say it is?
The Supreme Court says that we were at the age of 18, we were supposed to claim our minor status.
Nope, not valid.
Okay.
So here's what I would say to you. Mr. Dagger Margosian is, like most of our public defenders, exceptional attorneys. and very well versed in the law and very experienced. He gives legal advice. You may not like the legal advice, but it's usually good advice. I've never had anyone from the public defender's office not wholeheartedly try to represent their clients. So what you are talking about is not valid, and it is not going to get you out of this case. You're not going to be able to say all those things because it's not valid.
Everyone in this involved in this court case has a financial interest in the case.
I don't have a financial interest in your case. I get paid by the state of Michigan, whether you plead, whether it gets dismissed. I don't make any money off you. We have budgets. The court system is not a profit generating revenue. We are here to represent people so that people who are charged with crimes are protected. People who are victims of crimes are protected. And that's why we have.
But in order for there to be a crime, there has to be a victim. There is no.
Well, there is a victim in this case.
The victim would be the company.
You are charged.
I can't face.
Actually, just hold on. So your crime that you are charged with, which you are innocent as of this time, let me grab the right file, is failure. Oh, this is let me see. This is an embezzlement charge. So you are charged in count one with embezzlement 50,000 or more, but less than 100,000. That being an agent, servant, or employee of Hardwoods of Michigan Industries did convert to your own use without the consent of your employer or principal, industrial tools and equipment in the amount of $68,938.40 or money or equipment. And that's a 15-year felony. So if you are found guilty by a jury, you can go to prison for up to 15 years. You're charged in count two with using a computer to commit a crime. To facilitate the charge in count one, that carries a maximum penalty of up to 10 years in prison. And the way the statute is set up, I can actually stack those possibly. So you potentially could be looking at up to 25 years in prison. So the victim that's alleged in this would be that business.
Right, and I can't face that accuser because that business can't get on the stand for me to ask questions, and a third party.
But their representative can. Yes, they can. Yes, they can. Yes, they can. So I have 189,000 of student loan debt that was forgiven to be a lawyer. You do not. And Mr. Dagger Margosian, Mr. Isaac Sneed, all of the attorneys here went to law school to know the law, and their job is to advise you of the law. So yes, they can. Yes, you can be charged.
Everything, all the laws and statutes that you guys go by
are legal.
Corporations. They're for
still a crime. Still a crime.
But I'm not
still
a
crime.
Corporation. I'm a living person.
Yep, and that's why you're standing in front of me. If you were dead, the case would be dismissed.
Yeah, the all caps name is dead.
That means nothing. That's not valid. Okay. It's not legal. Right. So, do you want to represent yourself, or do you want to have an attorney to represent you?
I need some time to think.
Okay, so I'm going to set this for another pretrial on March 20th. At 8:30 in the morning. And Miss Adams, could I get a notice of hearing for Mr. Musgrove?
Yes, Judge.
All right, so Mr. Musgrove, have a seat on that bench right behind you. And then Miss Adams will give my bailiff a notice of hearing, and my bailiff will provide that notice of hearing to you.
Court does call the case, People versus Tariq Day.
Senior Assistant Prosecutor.
I am Tariq Maratari-Kade, the executor of the Tariq Maratari-Kade Living Trust and the registered owner of the Tariq Maratari-Kade Ex-Relatione Kingdomon Wilson Estate.
Right. So you are appearing here without an attorney. I do have to advise you that you are charged with the offense of fleeing and eluding in the 3rd degree under the Motor Vehicle Code. That is a felony punishable by up to 5 years incarceration and or $1,000 fine plus court costs. Additionally, the Secretary of State could suspend your driving privileges for up to a year. Do you understand that, sir?
I comprehend.
Do you understand?
I comprehend, yes.
The court has to further advise you that if you wish to be represented by counsel, the court would ensure that counsel would be appointed to represent you in this matter, and that you would have counsel if you could not afford to hire counsel yourself. I also wish to advise you that the court would be treating you the same as it would the people in this case. There are certain dangers to representing yourself in this matter, in that you will be required to abide by the Michigan court rules, the Michigan rules of evidence, and all of the cases and statutory requirements. You understand that?
I do not.
You do not. What is it about that you do not understand?
It's against my religion to adhere or to assimilate to any statutory.
Sir, I'm not asking anything about your religion. It is irrelevant, stating that in this proceeding, you will be required to abide by the rules of this court. Do you understand that?
I'm having a hard time understanding why or how religion doesn't play a role. How religion does not play a role.
Religion does not play a role in what I do or what this court does. There are certain rules of this court established by the legislature and the Michigan Supreme Court regarding how these particular proceedings will be conducted. These proceedings will be conducted in accord with those rules. Do you understand that, sir?
Well, according to the American Declaration on the Rights of Indigenous Peoples, as well as the international or the United Nations Declaration on the Rights of Indigenous Peoples, the state and the governments should.
Sir, you have no authority for what you're about to state, because what you're about to state is incorrect.
Oh, I am an Indigenous person.
No,
so
sir, what you're about to state is incorrect.
Well,
if you were on indigenous lands, if that's where you're going, then maybe you might be right. As it stands right now, this proceeding is not on indigenous land.
Well, that's a matter of perspective, sir.
It is, and the only perspective that's going to matter on that is mine. We are not on indigenous lands subject to indigenous or tribal rules. We're subject to the rules of the Michigan Supreme Court as they are promulgated, both in terms of procedure and evidence. Do you understand that that's what's happening, sir?
I do not.
What is it that you do not understand?
I don't understand.
Because I'm going to tell you something, sir. If you are unable to establish or understand what I'm saying, and go through this with you again, I have to assume that there may be some reason why you don't understand. This court will take precautions to protect your rights, and I will be sending you for a competency evaluation to make sure that you are competent to stand trial and to stand in these proceedings.
Well, I would agree to a competency if the prosecution, as well as the court and the officers agree to take a competency.
That's not the way it works. You don't get to make the rules. I'm ordering a competency.
I'm not making.
Defendant is ordered for a forensic evaluation. I will set a competency hearing in this matter for July 25th, 2024. At what time? At 9 a.m. Now, sir, I'm going to ask you this.
Yes, sir.
Because it's going to depend on where you may be staying for a period of time. If they send you information as to when you have your forensic interview,
yes, sir.
Are you going to cooperate and attend that interview?
Under threat, duress, and coercion, yes.
Pardon?
Under threat, duress, and coercion, yes.
No. Not how it works. I'm asking you, are you voluntarily going to cooperate?
I say yes. I mean, yeah, I mean, is this, is this, uh, what are, excuse me, what are you relaying to in regard, what are you insinuating in regards to where I will stay for a time?
I'm going to make sure that we are going to have our forensic interview done. I've ordered a forensic interview. I am asking you whether or not, when given notice of that interview, whether or not you are going to voluntarily cooperate in that interview.
I will take the interview.
Excuse me?
I will take the interview.
Anything from the people?
Would the court ask the people to prepare the order for the competency?
Yes, please prepare the order for the competency if you would, sir.
And the address for
The defendant.
I see on the complaint is 1410 Share Avenue, apartment 1-3.
Is that your address, sir?
Excuse me? That's correct.
All right, very good.
And so I will send a copy to that address.
Very good. All right. This time then bond is continued.
Yes, sir. And I'm sorry, can I get that date again, please, sir? I can put it in my calendar.
July 25th. You were supposed to, so I'm assuming you're waiving it. You were supposed to file your motion with.
I did. I filed it.
When did you file it?
I brought it in today.
Do we have it?
I gave it, I mean, it was stamped and everything. I gave it to the reception.
Why didn't you file it before?
Well, as I stated at the last hearing,
No, don't go through what you stated at the last hearing.
well, you
You
asked.
knew that, no, you knew it was supposed to be filed before the day. And man, you're gonna
That's it.
figure out something. We're playing by my rules, not yours. So you know, do not say anything because you're gonna figure that out real soon. Do they have it?
I have not received a response yet.
Since I'm sending in for a competency, I can't hear that. I can't hear his motion in any event. So I won't hear his motion at this time. He'll have to refile it timely if he's determined to be competent. So I'll have his bond continue. He can go. What?
I didn't get the last part that you said. The bond continued and what?
I said you can go.
Oh, okay, no problem.
Court does call the case, People versus Tariq Day.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Day, who is present via Zoom. Sir, can you please unmute and state your name for the record?
Tariq Day.
Thank you, Your Honor. I do have a greeting form. I neglected to turn in prior to the docket. However, this is the day and time set for PCC. To my understanding, Mr. Day was referred for competency. There was a failure to appear back in October at his competency review hearing. We do not yet have a report from the Forensic Center. I'd respect this request and adjournment.
Is this set for competency?
Don't have it marked.
It should be a competency hearing, and we don't have a new report.
Our office has not yet received one, Your Honor, unless the court is in receipt of one.
Well, there was the original one from August.
Yes, and we have no further evidence.
There's no further one.
Am I able to ask a question?
If you, well,
Mr. Day, you can email me or call me and we can discuss any questions you have.
Okay.
We can talk again.
I'll set a competency review hearing.
January 2nd.
I'll set this for January 2nd, 2025, 9 a.m. If we receive something, if we receive something prior to then, we'll move the date up. Okay? Bond will continue. Thank you.
Thank you, Your Honor.
I'm not threatening you. Say one more word and that's 30 days. 30 days.